Hi, everyone. Welcome to CCI Hironia's February Lunch and Learn webinar entitled Hindsight into 2020. I'm Sonia Hodis. I'm one of the many directors at CCI Hironia and a condo lawyer, as well as your moderator today. 2020 has been an interesting year for all of us for a variety of different reasons. And while COVID has taken up much of the discussion, life has continued, and the courts, as well as CAT, have continued to deal with condo cases. The courts and CAT did not slow down during COVID, and neither did condo disputes. So today we are going to take a look back at some of the important cases from 2020, and our speakers are going to provide their insights on the lessons learned from these cases. I'd like to take this opportunity now to thank our sponsors. Without them, we're not able to provide these webinars free of charge to our participants. And so we'd like to thank Integrity Property Management, FCS Fire Consulting Services, Bayshore Property Management, Common Ground Condo Law. Thank you to all of our sponsors, and I just ask everyone to maybe give them a thumbs up or reach out to them from time to time and just thank them for supporting CCI Hironia and supporting our efforts to be able to provide these webinars free of charge. So who is CCI? Well, CCI is a national organization. We are independent, nonprofit, and we were formed in 1982. We have chapters across the country, and there are 8 chapters in Ontario alone. CCI Hironia is one of those chapters, and we are the current winner of the Lorne Young Chapter of the Year Award for Tier 1. CCI's main objective is education. However, CCI also advocates for condos. We represent all of those involved in condos, from owners to directors to professionals, and we encourage all of these stakeholders to work together. If you want to experience the benefits of membership, and you're not currently a member of CCI, check out one of your local chapters and consider joining today. You can find a chapter near you by going to our national website, cci.ca, click on the Chapters tab, and then on Chapter Locations. Also, if you'd like to become a member of CCI Hironia, you can just go directly to our website, ccihironia.com, and join online. In addition, CCI National has a resource center with a great deal of material available for review relating to many condo-related issues, including COVID. You can access the National Resource Center on the national website, cci.ca, under the Resource Center tab, or you can just come to our website, ccihironia.com, and under the Resource Center tab, you'll just get a link to the national website. It's a great resource for a collection of information from across the country and our various chapters from coast to coast. Also, CCI Hironia is on Facebook, so don't forget to follow and like us and find out about our upcoming events. Also, our website will always have information about our upcoming events, and you can register online. And again, that's ccihironia.com. And our website also contains our new newsletter called Condo Buzz. So if you want to check it out, go to our website and read our first issue of Condo Buzz. If you've missed any of our webinars, recordings of the past webinars are found on the website, ccihironia.com, under the Resource Content tab. Just a couple of reminders: please mute your phones and don't unmute yourself during the session. If possible, please shut off your cameras as well. We are recording this webinar and we're trying to get the best recording available. The recording will be available on our website next week. If you have any trouble with your connection, you can just end the meeting and log in again. And as a last resort, you can always log in by phone. Details are found on your confirmation email that you got. We will be taking live questions from our speakers, for our speakers at the end of the webinar. So if you'd like to raise your hand at the end of the webinar to let me know you want to ask a question, we'll get those questions live. If you're on your phone, you can do that by pressing *9. If you're on any other device, if you just open your participants tab, there's a raise hand function that looks like a hand. You just click that. There's always the chat box, and you're free to put questions into the chat box during the webinar. We'll try our best to answer them. And our disclaimer that we just need to make sure that everyone is aware that the information you're being provided today is general information, may not apply to your specific fact situation. If you are a condo director and you want to use the protection of Section 37 of the Act, you do need to get an opinion about your specific fact situation from your own professionals. This webinar is not intended to provide you with the opinions that would protect you under Section 37 of the Act. In addition, information provided is current as of February 19th, 2021, and as things change rapidly, the information provided today may not be relevant or applicable at a future date. And this is obviously important if you're watching a recording of this webinar versus watching it live. Also, please be advised that references to the Ontario Act, the Condo Act is Ontario legislation, and any references to any other legislation is also reference to Ontario legislation. So let's get started with our great panel of speakers. Joining me today on this panel, we have Patricia Aaliyah of Aaliyah Associates and Chris Jakovitz of Common Ground Condo Law. Welcome, Patricia and Chris. Information about the speakers will be posted in the chat box along with their contact information. So the three of us are going to try and cover 15 cases in the time that we have. This is going to be a fast ride, so fasten your seat belts. So Chris, are you ready to get this ride going and start us off?
Absolutely. Thanks, Sonia, and hi, everybody. It's nice to have you aboard. So I'm going to talk about maybe perhaps 4, maybe 5 cases. And where I want to jump in is back on the concept of good faith in contracts. And it comes, this is a case that comes from Ottawa, and for 2 reasons. The condo corporations involved are in Ottawa, and next, it comes from the Supreme Court of Canada, which we don't get too terribly often in our condo cases. So that makes them especially notable. So this case is called Callow and Zollinger. And of course, when most people see that, they don't recognize that it's a condominium case because there's no condominium mentioned in the case name. But it is, in fact, a condo case. It's one of those cases where the condo manager was named first as a defendant, and we've got 10 condo corporations operating through a joint use committee or shared facilities committee, and they found themselves being a defendant in a lawsuit brought by one of their service provider contractors. I'm just going to start my video here just to reset my focus. Sorry, my camera's a little wonky today. The nuts and bolts of the case, and it goes back many years, but in 2013, these 10 shared facilities, 10 condo shared facilities engaged service providers to provide their landscaping. That landscaping firm was Callow. They had a summer landscaping contract and a winter landscaping contract. And during the summer contract, the shared facilities committee had decided that they were not going to continue or to sign the winter contract, but they sort of actively let the contractor not be any the wiser and say, oh yeah, the work is good. Yeah, we're probably going to be hiring you. And then of course, when it came time, the board had exercised its right under the current contract to terminate it and not continue with the fall contract, the winter contract. That contractor sued for breach of contract, even though the contract provided that the corporations could terminate the agreement. And at the initial case at trial, the contractor was successful in establishing that it had in fact been actively misled by the shared facilities committee members and the manager, and had undertaken extra work on the basis that, this is a long-term client, or they're going to be continuing to use my services, provided some freebies and turned away other work and acquired additional equipment to service that contract. And of course, was totally taken by surprise when advised that, no, the contract was terminated and there'd be no winter contract. So in that case where the trial judge had found that the management and shared facilities committee had actively and dishonestly had misled the service provider in that case, and so there wasn't really a breach of contract, but the fact that the defendants had misled the contractors, that had this duty of good faith in the piece. So it was really, really interesting. It went to the Court of Appeal, and the Court of Appeal said, wait a minute, you can't do that. That doesn't work. The contract says the condo corporations can terminate. They can terminate. Case appeal allowed, case overturned. And then, of course, it went to the Supreme Court of Canada. And of course, I think we could all probably count on one hand the number of cases that were involving condos that have gone to the Supreme Court in the last 10 or 15 or 20 years. But this one did. The court agreed to hear it, and they found that there is, in fact, this duty of acting honestly and in good faith in the performance of contracts. And even if your contract says, yeah, you can terminate it, you can't actively mislead the other party into thinking that you're going to do something when in fact you've already decided to do something else. So the court used this case to expand and clarify the law about about good faith in contracts, and it is an eye opener for several reasons. The first one is during the trial, or during the case leading up to trial, it was the plaintiff's lawyer had, through the oral discoveries in the litigation process, revealed this treasure trove of email, which was the smoking gun between the various the Shared Facilities Committee members, where basically it was pretty clear that they had decided to terminate that contract and to actively mislead the contractor. It was all there in the email, smoking gun. And in addition, the trial judge was not particularly impressed by the fact that the various directors and members of the SFC had basically given disingenuous testimony, shall we say, in open court to sort of downplay any suggestion that they were pleased with, or that whether or not they were pleased with the contractor and the work that had been done. And in fact, they were sort of resiling. They were giving a different story than they were giving to the contractor at the time. So the trial judge was not particularly impressed by that, and that went some way towards finding that the Shared Facilities Committee members did not act in good faith. And another thing that comes out of this is just the initial trial decision. It wasn't over a lot of money. It was basically that the contractor had won $80,000, most of which was the profit that it would have earned had the contract continued, because that contractor had turned away significant other work in order to be ready to service that contract, which he expected to continue. And part was for the acquisition of additional equipment that the contractor had purchased, relying on the contract to continue. And so, but it's very strange that over a relatively small amount of money, you've got, in this case, a very motivated plaintiff to take that case, not only to appeal, and then of course the Supreme Court of Canada. So I mean, you can just imagine the legal costs for a case of that nature compared to the amounts of money at issue. And just so that's the first of the takeaways here, to think about, finding a business-like solution to almost any kind of case, whether it's compliance cases, business cases, contract cases of any kind, always important. These cases can go a lot further than you ever anticipate. I'll bet you neither of those parties thought for a second that they would be at the Supreme Court of Canada at some point along the line. Nobody ever does. The next piece is, as I said, the role of email in that case was so incredibly important, and basically it destroyed the condominiums cases and their position. One thing, of course, we think about, and it's with the Condo Authority Tribunal, what they're doing nowadays and deciding on the issue of records, the stuff that goes on between directors and managers in email right now, at this time, it's not really all producible and out there, but there's always that risk, and that risk is increasing, whether it's part of the litigation process or condo unit owners looking for records. So, I mean, what you put in your email, be judicious. And if you want to have like candid and open discussions in meetings, that's where it should be happening. Watch what you put in email and keep a lid on it, and recognize, and don't write anything that you wouldn't want other people to see. So just that really is an important lesson. It's easier said than done, but it's important to be followed. And the very last thing I wanted to hit in that point, and during the COVID pandemic, we all found this, that treating your contractors well is so important. If you go stringing along your contractors or switching between contracts just to get the lowest price on any particular thing, when push comes to shove and worse comes to worse and you need to rely on your service providers, if you haven't got that good relationship there, you're going to be in really deep trouble. So that's a further thing to keep in mind. And of course, don't be penny wise and pound foolish. This group of condominiums out in Ottawa was, and it ended up costing them pretty dearly. So that's the Callow and Zollinger case. We'll be hearing about that case and its impact for years to come. The next case I want to talk about, and I'm going to drop one of them out. Another one is, this one comes out of British Columbia, out of its Civil Resolution Tribunal. They are basically the online body that hears condo cases, small claims court cases, insurance cases of different kinds. And they had a case over the validity of electronic meetings for a strata corporation, the equivalent of our condo corporation. And the CRT had found that for a number of reasons, a unit owners meeting called and held by the board and the voting methods that they used were not valid, and the decision made at the meeting, and the purpose of that meeting was to approve changes in the management contract. Basically, the board said we want to terminate this agreement and sign a new agreement, and that required the approval of the owners per their Condo Act, and a unit owner took exception with that, challenged it, and here you've got the CRT that's making all these rulings on these various parts of the meeting, including the way the notice was given, how was it served, what was the timing like, what happened at the meeting, what were the electronic voting processes like, and of course, like, so that is all very, very BC specific, but the reason it's important and that I got a kick out of it is because, of course, we've been doing electronic meetings for unit owners now since April or May at least, and we've done a whole bunch of them. We haven't had any significant litigation over that kind of stuff. But we know that somewhere down the line that the Condo Authority Tribunal here in Ontario will begin having some jurisdiction over some parts of condo owner meetings. And just looking at a case like this in BC, you just get that shiver down your spine that says, you know what, if you get owners that are unhappy with the result at any given meeting, and you know what, where meetings are invalid or there's significant failures in the protections for unit owners, I mean, those need to be avoided first of all, and then solved quickly. But I mean, where you've got disputes over the validity of those meetings and what's happening, and that those will go through the Condo Authority Tribunal or some similar body, because right now you can only take those cases to Superior Court. Nobody else has jurisdiction to overturn what happens at a unit owner meeting. But if we have cases going through there where, like, when you look at this particular case from BC and you say, well, the decision maker was looking at this part, this part, this part, this part, this part, this part. And I'm just going, wow, you know, it is just so vital that as always, that every part of the process be beyond reproach, that the notices are excellent, that the timing is good, that that every part is proper, and that the meeting is procedurally fair. And in that particular case, it took place, the meeting at issue took place during the pandemic, and that board had decided to say, well, we're going to do all the voting in advance by proxy, as opposed to actually allowing any voting at the meeting. That was a factor in the case. And of course, we've seen a number of meetings, especially early in our pandemic, where we weren't using the get quorum or the shift suite or the other available voting methods, but we had relied on those processes where we would, say, oh, we were going to rely on a proxy in advance. And that might have been okay during the initial days of the pandemic. I think we're all concluding, though, that no longer is acceptable. And as the technology has advanced, the cost has come down, and it is so important to hold a meeting that the owners see and believe to be procedurally fair. So
1 minute or less, your last case.
Thank you. And that takes me to my final point when we talked about, because I talked about timing of the notice in that last one. And some of you might think that it's pretty easy to count 10 days in condo land. And not everybody agrees. So of course we have to take it to court, and it has to go to the Court of Appeal. So I'm just at the beginning of 2020, our Court of Appeal released a decision that confirmed lower court rulings that 10 days means you exclude the day on which the thing starts. Like in that case, it was a Form 14 notice of lien. But you include the day on which the second thing happens, i.e. the day in which the condo lien is registered. So that's how you count 10 days. You exclude the day, you put it in the mail, but you can include the day on which you give you do the other thing. And of course, the last thing to keep in mind about all of that is where your 10-day notice period expires on a holiday. Like if you've given a notice that in the date deadline is Sunday, Well, the deadline is automatically included to Monday, or if you've named Christmas Day or Boxing Day or New Year's or whatever, it goes over to the next day. So that's something to think about. So I hope I haven't spooked you out too much. And the only point I want to make about the giving notices of the liens and the meetings is, folks, you've got to have your lawyers involved, and managers nowadays too sometimes may just want to get that little extra bit of advice when looking and tightening up their processes to make sure that you've got everything sewn up, and so that you avoid disputes about your meetings and your documents later, because it's incredibly easy for these things to be challenged, and you want to avoid a fight if you can. So I'm going to stop there, and I'll turn it back to you, Sonia. Thanks.
Okay, thanks, Chris. So Chris challenged Patricia and I to do 5 cases in 15 minutes. So I'm going to start my timer here. Chris, you're going to hold me accountable to these 15 minutes. And I promised Chris that Patricia and I could do it. So here we go. First case that I want to talk about is the York Condo Corp 266 versus Linhart. And this is a case, again, it's about smoking. We see these smoking cases all the time, but the important thing about this case is that it's a reminder to everyone that even though you've put in a no smoking rule with grandfathering provisions, that doesn't mean that a smoker who is under the grandfathering provision is always going to be able to continue to smoke. And this case is an example of where the condo revoked the grandfathering provisions. The owner challenged it, took it to court, and the court upheld the condo's decision to revoke the grandfathering provisions. So it's just a good reminder that those grandfathering provisions, when you're drafting these rules and including them, you want to make sure that they're properly drafted and that it gives the condominium corporation an opportunity to revoke it, where in cases of smoking, the owner still is allowed to smoke under grandfathering, but only to the extent that they're not creating a nuisance, which is what happened in this case. The owner smoking was permitted under the rules, but the smoking created a nuisance. The other important thing about this case is that the court commented very often about how the corporation itself followed the proper procedures to revoke. And so again, that's just an important reminder that if you've got policies in place or the grandfathering provision itself has procedures that need to be followed in order to revoke those grandfathering provisions, that you follow those procedures to a T, because the court's going to look to how you dealt with this. In this case, the condominium gave the owner several opportunities to try and correct the behavior and stop the nuisance. The owner didn't. And then they invoked the revocation of the grandfathering clause. So that's another very, very important thing. Interesting thing in this case, though, is at the end of the day, when it came to the issue of costs, although the owner lost, and typically in courts, costs are paid by the losing party, the corporation was asking for almost $7,500 in costs, and the court only awarded $500, which is a clear message saying that they were sympathetic to the owner. And they showed that sympathy on the cost side. So, it's a win for the condo, but in terms of financials, it's a big loss because they're not getting reimbursed on their costs. So case number 2 and 3 that I want to talk about are cases that are coming from CAT, the Condominium Authority Tribunal, and one case is going to talk about costs, and one case is going to talk about penalties. And in 2020, the jurisdiction of CAT was really limited to records for most of the year. The expanded jurisdiction just happened at the end, and so we never really saw any cases in 2020 about the expanded jurisdiction issue. So in terms of costs under the records request scheme, we know that the tribunal very rarely will award costs. It's like the unicorn that exists in CAT. You very rarely see it. If at all. But there is one case in 2020 where they did, and that's the Kamshan versus York Condo Corp 465. And what happened in this case, it was a director who brought an application against the Condo Corp, and he said he wanted to test the system to see how the Condo Corp responded to records requests. He asked for records, the Condo Corp gave them, but despite that, he continued to bring motions and continued this proceeding through the CAT process. And the CAT themselves actually brought a motion to dismiss the application on the basis that it had been dealt with. And the interesting thing, though, is that the case does award costs to the condo, not very many in terms of dollars, but it reinforces the CAT's position on costs, which I think we're all very familiar with now, and Chris alluded to it when he was speaking about his cases. But they make it very clear that the costs you get in court are not the same as the costs you get at a tribunal. And so tribunals don't typically order costs. And so there's going to have to be very unique circumstances. Now, they found in this case, because the director, the applicant in the case, brought this case for an improper purpose, that costs were warranted. But it's interesting because under the tribunal rules, they could award a penalty of up to $5,000. And in this case, the tribunal was quite upset with the director because he basically wasted tribunal resources. He also wasted a lot of the condominium's resources. The condo's costs were just over $8,500, and that's what they were seeking to be reimbursed. Interestingly enough, despite the fact that the tribunal was upset with the applicant, they only awarded the condo just over $3,200 in costs, so less than half of the condo's costs. But it's interesting when you juxtaposition that against the fact that they could order a $5,000 penalty, and they've done that against condo corps. They're not prepared to go that far with owners. So it's really it's a win, but it's kind of an empty win for the condo because they ended up having to spend a lot of money dealing with this issue. So switching now to penalties in CAT, we have a case that is the Meta versus Peel Condo Corp 389. And if you do any search of this case, there's several cases involving Mr. Meta and Peel Condo Corp 389. They tend to spend a lot of time at CAT. But the one case and they're all three cases that happened in 2020. I'm going to focus on the first case for a couple of reasons. One, this was a situation where the CAT awarded the maximum penalty of $5,000 against the condominium corporation. Now, the condominium corporation actually participated in this first hearing. As the second and third hearing went, they stopped participating. And we know that the CAT does not look kindly on condos that don't participate in the process. That's usually a basis to be able to award a penalty. But the other thing that's really important about this case is the message that they sent about self-managed condos. And I think this is a really important case. We do have a lot of self-managed condos in our jurisdiction. And they sent a very clear message that there is not going to be exceptions for self-managed condos. You're not going to be held to a lower standard. You're actually going to be held to the same standard as a condo that's managed professionally by a property manager. So their comments, and I just want to read this because I do think it's really important, especially for self-managed condos to understand. And they said, PCC 389 attempted to address the shortcomings in its record keeping by arguing that the Act provides little guidance on how to self-manage a corporation. I do not accept this explanation. Directors are required to undertake training, are expected to be aware of their responsibilities under the Act. Being self-managed does not excuse the board from these responsibilities and does not provide a reasonable excuse for denying an owner the opportunity to examine records to which they are entitled. So really important message. The other important message that this decision puts out there, which applies to all condos, whether you're self-managed or not, is the lack of a record. So say you say, I'm having board meetings, but I'm not going to keep minutes. So I don't have the board minutes to produce, so I don't have to produce it. And the tribunal has made it very clear that although they can't order the production of something that doesn't exist, the fact that you are not keeping records that you should be keeping under the Act, and especially the core records, minutes, financial statements, were two of the ones that they talked about in this case. The fact that they don't exist will definitely go to the issue of a penalty, because the non-existence of a record that you should have means that you don't have a reasonable excuse for not producing it. So they made it very clear in the subsequent decisions in Meta that they can't produce something that doesn't exist, but they're definitely going to take it into account when it comes to penalties. All right, so the next two cases that I'm going to cover in my last 6 minutes or so deal with noise, because in 2020, noise and nuisance has been a very hot topic. We have everybody in their condo units and making more noise than ever before, and lots of people who are not happy with it. So the first case that I wanted to talk about deals with a situation where the condo's actions in terms of dealing with the noise was actually upheld by the court as being reasonable. And this is the Zaman case versus Toronto Standard Corp 1643. And Mrs. Zaman is an owner, and for years she's been having noise issues. And the corporation did take steps to try and enforce. They wrote letters, they attended a mediation, they communicated with the owner, they sent demand letters, and at the end of the day, they even entered into an agreement with the offending unit to control the noise. And the agreement had some serious consequences if that didn't happen. Despite all of this, the noise continued. And so Ms. Zaman brought the corporation to court, alleging that their actions were oppressive because they didn't take enough steps. And interestingly enough, the court didn't grant the application and reaffirmed that the actions of the corporation were reasonable and therefore not oppressive. Now, interestingly enough, the Condo Corp, although they won the application, the court did point out a couple things that they didn't do right. And one of the things that they sort of got their hands slapped on was with respect to not disclosing the minutes of settlement that they entered into with the unit upstairs. And so the court found that was something that the condo made a mistake with respect to their actions. But the fact is that they did respond. So they didn't ignore the complaints. They did respond. They sent out demand letters. They continued to send out demand letters when complaints were received. They attended a mediation, and then they entered into this agreement. Those were all reasonable steps. The court is not requiring the condo to change the behavior of the unit owner who's creating the noise, or to go to the extent of having to actually stop the noise. And that's an interesting sort of result of this decision. Now, the fact that the condo wasn't perfect in their actions and they did make this mistake with respect to their failure to disclose the settlement, what the court did do is they took that into account when they ordered costs. And the court made a point of distinguishing the actions of the condo in this case against the actions of condos in other nuisance cases from the past, the Wu case, the Dyke case, and the Mohammed case. And in all of those cases, the corporation really didn't take any action. And so the court distinguished it and said, in this case, the corporation did take some action and it was enough, but they should have disclosed the settlement. And so in terms of costs, they asked for $36,000, they only got $12,000. So that's where their mistake got taken into account. The other nuisance noise case that I want to talk about is the Mtcc 933 versus Lynn. And this was a case involving an owner and a tenant, and the tenant was creating the noise problem. There was another unit that had a tenant that was complaining about the noise. And at the end of the day, the court found that the tenant was creating a nuisance, and they gave the compliance orders with respect to the nuisance. What's really interesting about this case is that the court did not order costs against the owner, which means, and against the unit, which means that the corporation could not collect their costs because the cost award was only against the tenant. And there's probably very little chance that they're going to collect that cost award. The court made a big point in their decision about saying why the owner should not have to pay costs. It's a disappointing decision because it's a very hollow victory for condos. The condo having to go through the extent to get the tenant to comply and then not being able to recoup their costs against the unit, that's not the direction we want cases to go. Fortunately, there are other cases that support the owner having to pay. And I think, hopefully this case will be able to be distinguished on its facts. What the court was upset about is that the first two notices that went out didn't reach the owner. They didn't have the right address for the owner on the letter, although they had the right address in the record. So that's a very good lesson for everybody to take away. Please make sure when you're sending out your letters that when you're dealing with a situation with unit owners and tenants, that it goes to both of them and that you've got the correct address for the owner so that the owner gets notice of it. Because that's one thing the court did not like. But the key thing, I think, which is probably the distinguishing factor in this case and can easily be remedied by condos going forward, is the court was upset that the condominium corporation did not help the owner with any kind of proceeding at the residential tenancies tribunal to evict the tenant. They didn't provide any evidence. They weren't cooperating with the owner to allow the owner to evict the tenant themselves. And I think that is the big distinguishing factor. So lesson to be learned, when you're dealing with owners and tenants, be cooperative in terms of helping the owner. If you're trying to get the tenant out because they're causing a problem, help the owner do that. You've got, as a condo corp, you've got a lot of the documentation and the evidence to be able to help them to do that. So Chris, did I make it within my 15 minutes?
Clock reads 14:57, 58, 59. Nicely done.
Woohoo, I did it. Okay, so now, Patricia, please don't let me down. Let's keep the record going because Chris didn't think you were going to be able to do it.
All right, well, keep the time moving and let me know if how I'm doing.
Okay.
So I'm going to talk about several other cases that are also equally exciting and put us in make us think about a variety of things. The first one is Mtcc 590 and the unit owners. So it's everybody suing each other here. And what it was, though, it's a very unique building. The top floors of the building have wood-burning fireplaces, and each fireplace has a chimney flue that vents to the roof. So what you're trying to picture here is from within the unit up through the common elements out to the roof. From 2013 to 2017, the corporation got engineering reports and found out that the fireplaces were no longer safe to use. The fireplaces and the chimney flues had to be replaced, removed, or decommissioned. Now, everybody knew about the fireplaces when they bought into it. Everybody knew that some had them, some didn't. And so what ended up happening is nobody could actually decide. And there were a lot of lawyers, I think, that gave opinions on this issue. And so they went to court. And the issue was, should the corporation be granted an order to amend the declaration to specify that the chimney flues in each individual unit be the exclusive use common element for the unit? And also, should they be granted an order to amend the responsibilities? So as you know, under the Act, we can amend through our deck the responsibilities for maintenance and repair. But here, the drafter did not. They did not have all the language that they needed to cover this issue. And so what the corp decided, initially was, we're not going to pay for it. You unit owners are responsible. Of course, that started a rebellion, and we ended up in court. So what ended up happening at the court level is that the court, interestingly enough, and from what I could read, with not substantive, really clear evidence on what the declarant's intention was, amended the declaration, made it exclusive use common element, but held the corporation responsible still for paying for the rectifications. Interesting reinterpretation. And this was done under Section 109, which is you get to amend if you can prove an error or inconsistency. I personally don't see any evidence that there was an error. What if that was the way it was intended to be? And what if the reserve fund was funded based on this premise, which it was in actual fact? Well, then the decision was appealed, and the question arose as to whether the judge erred in dismissing the condo's application to amend the declaration to provide that the owners of the units with the fireplaces were responsible for maintenance and repair of all exclusive use common elements. Because the issue was, well, what happens if there's if there's an event that triggers that there's damage or there's wear and tear? So they wanted it broader, and the Court of Appeal agreed that the judge had erred, created a further inconsistency, and wanted to rectify it. And so what they did is they did rectify it by proposing language, but it was still up to the parties to agree. The court found that the intention was to clearly place on the unit owners the duty to maintain and repair their unit and to maintain and repair any part of the common elements over which they have exclusive use after normal wear and tear or the efflection of time. So it's also in the event that things just break down, okay? And to do so at their own expense. And reaching the conclusion, the court stressed that the use of the words any part of the exclusive use common elements that are used in part of the deck was important to in this interpretation. So the court held that the original order be set aside, and in its place an order was granted amending the deck in a manner to be agreed upon by the parties. So, to me, what the challenge is here is meeting the threshold of proof, shifting what we bought into. Because I think one of the challenges of this case, again, was how the building was designed, how the chimneys work, because not all chimneys, for example, are individual. Sometimes they could join. And what was the declarant thinking about? And there was evidence in this declaration that the declarant had thought about exclusive use common element and specifically did not note this as an exclusive use common element. So I think we need to be thoughtful about where that case takes us and what kind of challenges it will present in the future where we want to amend declarations. Now, Lozano and Tscc 1765 is another interesting case. The Lozanos had replaced a float in the toilet tank of their bathroom and that had developed a crack in 2018. The owners then left the country later that year for approximately 5 months, returning in April 2019. And during that time, they had a family member and friend visit the unit biweekly. In early 2019, a water leak had begun from the toilet. And the corporation retained a plumber who reported that the leak had occurred as a result of a broken ball cock at the base of the stem, which caused water to constantly fill and overflow the toilet. The leak caused damage to the owner's unit and the units and hallways below. The corporation bylaw provided that when an owner commits an act or omission that leads to damage, the owner will be liable to pay the lesser of the cost of the repair and the deductible limit of the corporation's insurance deductible pursuant to 105. The corporation eventually registered a lien against the unit for the cost of the repair and the legal costs, which the owners paid under protest. The owners sought a court declaration that the corporation had no lawful right to charge back the repair costs to the unit because they did not commit an act or omission. Now, and I think this was a very creative position to take. That would make them responsible. The owners submitted that they maintained the unit and that the repairs were promptly made in 2018. The owners asked the court to consider a higher negligence threshold of proving an act or omission, which would mean that no unit owner could be held financially responsible for repair costs except in cases where they deliberately caused damage. And so, this is one of these challenges where you're thinking about where the cause is emanating from within the unit. And remember, corporations do not go in and necessarily inspect regularly all the plumbing, all the fixtures, electrical, etc. They're in the care and control of the party that owns the unit. So the corporation asserted that the owners had committed an act by failing to have a plumber repair their toilet when the plastic parts first showed sign of decay in 2018 and should have replaced the entire toilet parts and not just a component. So, can the corporation charge back the plumber's cost? Did the owners commit an act or omission? The court ultimately found that the owners did commit an act or omission in failing to maintain their toilet and having it inspected by a plumber. The decision was appealed, but it was dismissed by the appellate judge and found that the application judge made no errors of law and no culpable errors of fact. The court reviewed the legal framework in the case law regarding the chargeback of this nature, noting that the standard for establishing an act or omission is neither negligence or strict liability. It's somewhere in between. And I think that's very important to recognize, and it's a fair comment. Owners must act reasonably in maintaining their units, but an unforeseen incident will not absolve a unit owner of their financial responsibilities towards repair costs. An act or omission does not have to be negligent, and the damage does not have to be foreseeable to make an owner liable for the cost of repair. Even when an owner is not aware that a unit component is broken, the court nevertheless found that this constituted an obvious omission to maintain and repair the components for which the owner was liable. Sonia, you're smiling. Is it all right? And how am I doing for time? Good?
You're
All
good.
right.
You got 6.5 minutes.
Excellent. We can do this. Rock on. So it's important to recognize that we're trying to allocate the responsibility in the area of control. And I think this was a great finding on behalf of the courts. So the next one, TSCC 1704 and Fraser, another one of our favorite cases during COVID. And this is originating in repairs to the unit during, and what happened was Ms. Fraser's unit was flooded during plumbing repairs in early 2020. She requested permission to repair damage to the floors in her unit. The Condo Corp refused permission due to missing documentation and other reasons, and then it implemented in May 2020 a policy to restrict repairs to the unit in response to a COVID-19 concerns. And so they had a policy, okay? And there were 4 major issues to address in this case. The CC's condominiums policy, was it valid and enforceable? Yes. Were the condo's actions in enforcing the policy unfair, unreasonable, or prejudicial towards Ms. Fraser? No. Should the Ms. Fraser repairs were an emergency, and should they have been allowed to proceed? They were not an emergency. And should Ms. Fraser pay the cost of the application? Yes. So what's the importance of this case? Good policies that are reasonably written during COVID to manage the risk and transmission of the virus will be upheld. But as long as we are practically enforcing, we're being consistent, and we're being reasonable. There has to be a measure of reasonableness, and I know condos have been great. They've been trying to be flexible. They're trying to manage all the data. But here they found that Ms. Fraser was not at risk. It wasn't an emergency. And I think that's important as we go forward. Next week, Beswick and YRCC Condominium Corporation 1175. Really an unfortunate case, bad decision making. You see a group of townhouse unit owners bringing an application against the corporation for oppression because they're being sort of not being kept in the loop. The deck is not being adhered to. So what happened is the corp decided that exclusive use common elements of their townhouses and the fronts of those common elements, which were steps, were going to be changed. They didn't tell the unit owners, they didn't warn them, and then they handed them a bill for $5,000. The court said, absolutely not. You should have given them the opportunity, because they were actually responsible for maintenance and repair and replacement, to actually give them the opportunity to find their own service providers. Was not provided. Water charges were also provided them, billed to them incorrectly, contrary to the deck. Court said, you can't do that. That's not appropriate. Snow removal. They were charged extra for snow removal and landscaping. Again, contrary to the deck. That was not allowed. So here we found that these individuals, as townhouse owners versus the other part of the corp, which were multi-story, were being treated differently. And the court criticized the board for the poor management of these issues and its poor communication skills. You can't make it up as you go. You have to follow the parameters of what's in front of you. Ching and CCC 203. How are we doing, Sonia? What's our time? All right, Ching, we can do this. In Ching, a couple purchased and resided in a condo unit as their matrimonial home. Only the husband was registered on title as owner of the unit. The couple separated in 2014. Ching moved out. The owner continued to reside in the unit. And in 2015, under the Family Law Act, Ching actually had registered a DMH, a notice that was put on title. And the notice can contain anything. And this contained a claim to the title. 2017, the owner on title defaulted in the payment of the common expenses. Condo began to take steps and began to register a lien. Ching was left out of actual notice and it didn't even know about this. Only when it got to trying to sell the unit did this person find out. And this person under family law would have a right and an interest in the property. It was held that the lien was not validly registered. It did not provide actual proper notice. What did that do? It actually changed the law and how we actually approach liens. Because now what needs to happen is you really need to be cognizant about all the instruments on title, What does the notice say? Does it create an obligation now to provide notice because of a real estate interest held in the title of the unit? Therefore, pushing forward to the front, more of the legal costs that go into searching title and ensuring that notice and the lien process is conducted correctly amongst all the parties that should be on title. Done. Yeah, right on.
You still got time to keep talking about it. We can even debate that case if we want now.
Yeah, we've still got a minute. Patricia, you were amazing. So
a minute?
So
what am I going to do with myself?
Well, I'm going to propose this, Patricia. The next time we're able to get together in person, Chris owes both of us a dinner because we do it in 15 minutes. 5 cases.
Hey, she's negotiating this. This is great. I think it's good.
And we've got it recorded with 105 people watching, Chris. So
I got to pony up on that one.
Thanks, Patricia. All right. So our next sort of portion of this webinar, instead of sort of fighting amongst the three of us who was going to talk about this sort of seminal case of 2020, Mtcc, and if you haven't heard about Mtcc, you're gonna know about it in the next 15 minutes. We decided that what we were going to do is we were going to all talk about Mtcc from different perspectives. So, Patricia, why don't you start off and give us sort of an intro to Mtcc and put it into context? And I think you're going to talk about Italiano as well as part of your portion of it. So take it away.
All right. Thanks very much. So Mtcc is a very important case and is garnering a lot of attention, and it requires a lot of thoughtfulness, in my opinion. Mr. and Mrs. Mtcc went to court to save their apartment from being sold under power of sale proceedings, which was the result of a lien. In this case, Section 85 was used to register a lien, and Section 134 was used to justify expenses made in respect of compliance. In addition, the applicants brought a counterposition in the felt that they were being oppressed under Section 135 of the Act. The corporation wanted to collect about $25,000 in costs. And condominium liens are put in place to protect cash flow of the condominium corporation where unit owners don't pay. And what's important here are some of the really key facts. Mr. Mtcc was a smoker, but he was very thoughtful in his purchasing of this unit. Corporation and the units at that time permitted smoking. And what ended up happening is that Mr. Mtcc, decided to purchase, checked with his real estate agent, made sure smoking was possible. And then what happened, there was a bylaw passed to not permit smoking. Okay, but certain parties were actually permitted or grandfathered. And in these facts, I'm going to say that sometimes bad facts make bad law. And that's one of the things about this case is that Mr. Mtcc did his best to reconcile his position. He even moved out of the condominium corporation during his dispute with the condo about the complaints that had been made about his smoking. So he took proactive steps. He tried to speak to the board. They did attempt mediation, which failed I would say it failed because of a lack of good faith and integrity in proceeding with the concept of mediation. And then, he also then incurred $25,000 of legal costs after he had moved out, which I think is an interesting fact. And also he asked for the ability to be grandfathered and was told he could not be grandfathered because he wasn't a resident. But the reason he wasn't a resident is because he had moved out while the dispute was ongoing. And so to me, there were a lot of sort of factual things that everybody kept tripping over here. But in the analysis, there was also this contemplation of Section 85 and what's its purpose, and Section 134 and what is its purpose. And so what I'm going to talk about is Italiano. There's another case out there which predates this. And the Italiano case was about an individual at a condominium corporation that had a lot of complaints against him about noise emanating from the unit. Common thing. And there was an arbitration. The Arbitrators Award consisted of 2 orders, which that Mr. Italiano comply with the deck and the rules, and to pay the corporation's costs. And what was important there is that the corporation's declaration had an indemnification that would cover, as a common expense, the cost of enforcement. And it was found that, on the appeal, and that's how we all found out about it, did Mr. Italiano contravene the deck and the bylaws? And should he be forced to comply? Yes, he was found to actually have breached. And then it was found that, the question was about the expenses. But the key thing for Italiano in our dialogue today about Emlani is the fact that it was held that an indemnity can actually include the ability to create common expenses. So before I pass it over to Sonia and to Chris, I just wanted to just set another little bit of context. When you buy a condo unit, you purchase a legal fiction. I hate to say it. It's like a box in the air. But the box is defined not just by physical boundaries, a legal description, but the act, the deck, the bylaws, and the rules. That's our contract. And it's been upheld, Mtcc 1385 and Skyline. You can think about all the cases that confirm that. Why? We buy with knowledge. We know what we're getting into. Then we also need to think about the act, and we need to think about several sections that work together. Section 7.4 says that we can make statements in our declaration about common expenses. Section 85 tells us when we can lien and what happens when we don't pay a common expense. Section 119 creates an expectation in the managing of the assets of the corporation, in the duty of our scope, that everybody will comply with the act, deck, and the bylaws. Section 134 then talks about when we need an order to effect compliance. So then we also have the actual constating documents, which could include an indemnity that covers not just damage to common elements, but could also include the cost of compliance. That's what Amlani does. Amlani does a great analysis, but what's happening is we're forgetting how to connect the dots. And this is where I'd like to maybe turn it over to Sonia and Chris to connect the dots further, and we can expand on our conversation. Is that all right with you guys?
Yeah, no, that's great. So I'll start because I'm going to talk about communication, and Chris, I think, is going to talk about the impact of costs, recovery, and enforcement. And the communication issue is, it's something that really needs to be highlighted in this case. This case is a perfect example of what a condo corp should not do when they're handling a nuisance complaint. I've said this before in a variety of different seminars that I've participated in. Communication is key for condos. And if you do it right, it will benefit you. If you do it wrong, as Chris is going to explain, it's going to cost you a hell of a lot of money. So I'm going to just focus on what the corporation did wrong. And hopefully by pointing out what they did wrong, everyone listening is going to do the opposite to make sure that what they do is the right thing. So that they don't end up in the same situation that the condo corp in this case ended up. So it's very interesting, this case, because the judge in this case, like throughout the case, numerous times made very extensive comments about the communication strategy of the condo, and didn't appreciate how the condo handled this. But he didn't just say it once; he said it 2, 3, 4, 5 times. And so, had the condo implemented a better communication strategy, I wonder whether the lien would have been enforced, and I wonder whether the court action would have even have been necessary. Right? That's really what would have happened had they done it right. One of the things the court highlighted was that this condo corp has a bylaw, and this is your homework for today. Go and check your bylaws this weekend and see if your bylaws or your deck or any policies or any rules have a similar type of language or provision. And the bylaws in this case contained a clause that required owners and the corporation to use their best efforts to resolve any disputes through good faith negotiations before they even went to mediation and arbitration. And the court pointed this out a couple times. So I think that's a really important point in terms of communication. If your governing docs, which Patricia was just talking about, sets out an obligation to communicate ahead of sort of starting any formal kind of proceedings, and mediation and arbitration are still formal proceedings, although they're more informal than a court proceeding. There's still a formal proceeding. And if you have this obligation in your governing docs, you better start communicating with the parties before you start slamming the hammer down and threatening costs and chargebacks and stuff like that. I think even if you don't have it in your governing docs, the directors have a duty to act in good faith. And I think, given the comments in MLANI about communication and the directors and Condo Corp's lack of good faith, I think you would still, under the Act, have this obligation to do this. Now, the court found that the condo's unwillingness to communicate with the owner, despite the fact that the owner was more than willing to communicate and cooperate and try to find a practical solution that would benefit everybody, the fact is the condo was not willing to do so. They were very entrenched in their position. They went from a previous incident of actually finding a solution that worked a couple years ago to this situation where they basically are asking the owner to stop smoking. And they close their mind to any practical solutions, despite the fact that their own expert on cross-examination admitted that there are simple solutions that could rectify the problem. So another good lesson in terms of communication is that communication is just not the physical act of talking. Communication is also effective. You have to, in order for it to be effective, you have to keep an open mind to different possibilities and different solutions. Don't become entrenched in one position. And here the court definitely did not approve of the condo being entrenched in their position. The court also held that had the condo acted in good faith, they could have found a solution that met the goals of all condo residents. And they reinforced the fact that the director's responsibility is to really act on behalf of all owners. And so again, your communication strategy has to take that into account, that your duty is basically to, as they described it, to find the greatest good for the greatest number of people. And the failure to meet and negotiate with the owner was unreasonable. And that's an important thing to keep in mind, because in MLANI and in some of the other cases that we've seen last year, there was lots of discussion about this business judgment rule. And the business judgment rule applies to condos. We know that it does, but it requires condos, in order to take advantage of the business judgment rule, which basically says that the court will take a hands-off approach in terms of second-guessing the decisions of the board, provided that the board acts honestly, prudently, in good faith, and on reasonable grounds. So although the court may make a different decision, as long as the director's decision is in the realm of possibilities, they're not going to interfere with it. The fact that the court failed to meet and negotiate with the owner, and the court found that it was unreasonable, basically allowed the court to step in and judge this on their own and not defer to the condominium corporation. So at the end of the day, what did the condo do wrong? They refused to meet with the owner. They refused to talk to the owner. They refused to negotiate with the owner. When they retained their expert, they told their expert that they wanted a report on whether there was the possibility of a perfect seal, which was not the issue in the case. So this is another communication thing, is you got to be careful on what you're talking and giving instructions to with respect to your experts in terms of what the actual issues are. The court said the issue was not a perfect seal. The issue was were there any practical solutions that could reduce the transfer of smoke. And at the end of the day, the court said all of these were communication mistakes that the condo made. And really, it's the last part of the decision, if you want to read it, starting at paragraph 64, going into paragraph 90. I encourage people to read it because it's a really good discussion about what you should and shouldn't do on communication. Unfortunately, we don't have time right now to go into all that detail, but I'm going to pass it off to Chris, and you can explain to everyone what happens when you don't communicate properly.
Well, I think everyone knows, and it's no big surprise, anytime any of us, when lawyers get involved in a condo dispute, it gets awfully expensive, awfully fast. And the other thing is the landscape is changing so fast. I'm going to talk a little bit about how some of this trickles down into the Condo Authority Tribunal. also, there's news in that front too that we'll be watching about and you'll be hearing about more in the coming weeks. Sonia's point is so important about communicating effectively with the unit owner and with solving these things in a conciliatory way, or at least if they're not going to get resolved, that the condo corporation is exercising its approach in a reasonable, graduated, escalating way. It just is so important. This case is one in a long series of cases that all of us look at and shake our heads at, that make the newspapers. It's like the $40,000 parrot case from 10 or so years ago. It's one of those things that got government to look at the Condo Act and say, this is completely wrong what's happening here. And how is it that we're bankrupting unit owners and these condo corporations are getting shredded and divided because of, little rule enforcement issues like this that go way beyond what they should? That was the genesis of a lot of the changes that came into the Condo Act and with the 2015 statute that are being rolled out gradually, and where that's going to be impacting us nowadays. Like unit owners and condo boards might say, well, you know what, this distinction between the wording in our declaration and our bylaws it sounds really are the distinctions that terribly important? And, us lawyers, of course, would say, of course, they're important. They're incredibly important. But the practical effect is, my prediction in the coming months and years, as courts have, because the courts are sick and tired of hearing the condo cases, the statute now is moving these cases from the superior courts into the Condo Authority Tribunal that is far more accessible, easy to deal with, and easy for the unit owners to access, and arguably less expensive. But the thing is, those cases get incredibly complicated. There's a lot of evidence. Dealing online through an online tribunal as opposed to the traditional court process is not necessarily cheaper. And there's a learning curve for us to be able to go through that process. We are because only in October 2020, that tribunal began hearing cases about parking, pets, and storage. And of course, in the coming weeks, months, and years, that'll begin hearing other rule enforcement cases and noise and nuisances. So these cases that we've talked about that came from Superior Court on these issues, they're not going to be in Superior Court for much longer. They're all going to be in the Condo Authority Tribunal. And right now, the composition of that tribunal, or its setup, or its principles, is that condo corporations will not generally recover your legal fees. So the conversation we're having is a great one. We lawyers love it, about what does the declaration say? And the fact is, it's not going to matter in a short period of time, because that tribunal is just going to say, I don't care what your declaration says in that case. We're simply, our tribunal does not award costs, except for in extraordinary cases. So my takeaway from this, of course, is you condo boards, again, and managers have to do whatever you can to resolve the dispute in-house. If it is going to go into the Condo Authority Tribunal, first of all, anything can happen there. It is less predictable than the court process ever was. And of course, the costs can absolutely run away. Many condo corporations right now who are using their managers or members of their board to represent them in the cases dealing with records and things like that, that's probably working out okay. But in many cases, it may not. And there might be other unintentional consequences or costs or bad results or whatever. Maybe it doesn't make that much of a difference. In some cases, it may. And just in the end, there will be increasingly less certainty and more uncertainty about the outcome, the results, the costs of these things. And we're at an interesting point now where we're switching away from some of the Superior Court cases more into the CAT cases. We don't know how those cases are going to go. We've got our Superior Court cases right now that are going to guide the CAT. But will they actually, how will they evolve over time? What about this issue of legal costs? Is that tribunal going to make it more difficult for directors and managers to run their condominiums and paper their files and advance cases like this? Like, we're just at the beginning of this. It's going to be a really interesting few years. But I think if there's any point that I would make, it is, the old days where you could just sick lawyers on any problem that you had and expect that that's going to go away. That's the days of that are over. They will not work. They're already, that concept is unraveling as we speak, and it will only continue to deteriorate. So we're in a sort of a brave new world, and we're just beginning to understand the repercussions and the ripples of this. So it's on that happy note, I'm going to turn it back to the panel.
Thanks, Chris. I feel like I just got something dumped in my lap.
Yeah.
I mean, I think an important, following up to Chris's comments, I think an important lesson for condos at this point in time, especially since there's so much uncertainty in terms of what CAT is going to do with costs, is you really have to start budgeting the costs for legals into your budgets, because you're not going to necessarily be recouping them. So they're going to be a common expense that all owners are going to be sharing. And so, I see budgets that are like, $500 for legals, and I'm like, you're not even going to get a letter out the door. So start looking at your budgets more closely and make sure that you've got enough budgeted there to cover these types of issues at CAT. Because the other thing to remember is that owners can go to CAT for very little money. Right? It's very easy for them to start claims, and you've got to defend them, which means you're either doing it on your own or you're hiring people to represent you. And as CAT gets a bigger jurisdiction and gets dealing with more serious issues, I think you're gonna have bigger budgets in terms of expenses. Patricia?
Okay, and I'm going to bring this as a condominium owner and a condominium director. So forget that I'm a lawyer for just 1 minute. Why do I have to pay for somebody else's non-compliance? I thought the whole premise of consumer protection was to protect me as a condominium owner. And secondly, there is a body of law, and with no, tend to disrespect anybody, but just because there's a tribunal, that law should not disappear, in my opinion. I think the law has been there since 1968, when the first condo arrived in Ontario. There has been an aggregating of case law. And so to me, I don't believe that there is now all of a sudden the right to redraft legislation or declarations. Because here's the other position. I, as a condo owner, have bought into a deck, bylaws and rules. And if we democratically as a group change it according to the act, you get your 90%, 80%, 66 and 2/3, or 50% plus one, great. Then we've changed it democratically. But what I'm hearing, Chris, and I'm going to pick on you a little, you're saying that somebody can go and change my contract? That I have case law that says that that's binding. So I don't think that the intention of consumer protection is being fulfilled if I end up paying for somebody else's non-compliance.
It's
how is that fair?
It's interesting how basically the model is changing, and the principles underlying how condo disputes are handled and dealt with and decided has now fundamentally shifted, and that, for instance, it is the individual, it is that owner, it is that person, and who has it. So the collective, be damned. I mean, and when you think of it, the collective has elected the board. And if that board is going to say, well, we're going to enforce our rules because that's the right thing for our community. And condo boards, of course, have a duty to uphold and enforce their rules where it's reasonable, to whatever extent is reasonable. And not to run their condominiums like a gulag, not to act oppressively, to be judicious and to be, and to act in a sensible, reasonable way. And of course, so the decisions of the directors then are visited upon all of the unit owners. But it really, and the thing, I've said this quote a little bit now. It's not all that funny, but there's no me in condominium. That unfortunately, that's not the trend, and it's going exactly the opposite way. It is going that way in terms of, so here's an individual who can, whether they are right or not, whether they are able to take their condominium and to put it through whatever might be done. There's a balance to be struck here. I'm trying to be even-handed, but I, of course, do condominium side stuff, and our job is to counsel condo corporations to get out of this intact. But it's just, things have shifted, and I think irretrievably, or at least it's going that way.
I think, Patricia, you're dead on, and I don't think it's an issue of principle. I think it's an issue of application. And I'm going to be a bit optimistic. CAT has just expanded its jurisdiction, so they're now getting into issues other than records. And I think if I want to sort of give CAT a bit of a heads up, although I'm not very happy with a lot of their decisions, but records requests, there was a very strong feeling under consumer protection umbrella that owners are entitled to records, and there should be very few situations where corporations should be refusing records. And maybe that's why they're taking such a hard stance. I'm going to be a bit optimistic and hope that they will respect the declaration and the bylaws that have been accepted by the owners. I'm going to hope that they're going to respect the case law that the courts have set up. And then we're going to have to wait and see if I change my opinion about CAT at the end of this year, because now they would have had plenty of opportunity to show us how they're going to apply that. Part of the problem is their rules of practice are very strict, and they need to change those rules of practice. And I'm not sure if that's going to be happening anytime soon. But I think the government, if they're going to continue to expand the jurisdiction of CAT, they have to recognize these principles that are long-standing that Patricia was talking about.
And, I would add to that to say, what I think it would be great is changing the rules. Because here's the thing, a person wrote those rules. And sure, they put thought and consideration into it. But if the rules don't fit, because we're talking about people, if we're really going to look at it, we're saying, me as a representative of the community or me on the board, we're taken to task and we weren't even supposed to be taken to task. Why shouldn't there be flexibility in the rules to say the party that pushed this should pay the costs? Right now, you're going to increase the work of the board. You're going to increase the risk exposure. Boards are going to have to get more opinions. And so what's happened is you're escalating the cost operationally. This is the concern I have, as well as you're creating this level of risk. Fortunately in Emlani, there was professional guidance on what the board did. But what happens when everybody starts going, well, now we need an opinion for this and this and this and this and this and this, and we may not get our costs back. Well, we're not going to get the opinion. We don't want the opinion because we're not going to get it back. Well, we're actually feeding our own demise, like our own undoing, because what will happen is then people will make false moves without knowing the context, right? Because if you only rely on Emlani as your guiding decision, you're going to make a misinterpretation, and I know colleagues of mine, ours at the bar, that actually misinterpret Emlani. And there's a case out there now, O'Regan, that distinguishes and corrects and clarifies a little bit of Emlani. So, this is the thing, like, are we actually, are consumers being protected or are we not? Like, am I now more exposed? Because I'm concerned too, because I sit on a board. I'm like, well,
I think
this is concerning.
Chris, before you answer, I just want to remind people, if you want to ask a question live, raise your hand. We'll take questions. I'm going to let Chris continue his comments, but if you want to ask a question live, please feel free to raise your hand. *9 if you're on your phone, and we'll let you ask your questions live. Go ahead, Chris.
Great, thanks, Sonia. I'm really hopeful that this shift in the thinking and the prominence on the individual as opposed to the collective. I hope it's a temporary kind of thing. And one thing I just want to point out in the records cases dealing with the Condo Authority Tribunal, like the allocation of common expenses, like anything the condo does, you sue the condo board, you're basically suing yourself because you're paying that portion of the condo corporation's costs. What the Condo Authority Tribunal does with its cost award, it says, okay, I'm giving this owner a cost award, let them pay their filing. I'm going to have them repaid their filing fee, maybe this little penalty. And by the way, a little top up there to the equivalent of what that owner's share would have been of the common expenses. And I have always found that to be perverse for the simple fact it completely ignores and takes away from the fact that, you know what? As a unit owner, you are partly responsible for that condo corporation's financial affairs. Good for you. You won a case. You get a cost award, but you still pay your share of the common expenses. Because if you take that away, now you create this moral hazard where it says, you know what, now the condo corporation, it's like the supermarket. I can sue them. I can enrich myself in that way. Like, and that's an extreme example. It doesn't go that far usually, but it's a concept now that is there, and it undermines the concept that you are a member of a collective. And as I said, there's no me in condominium. Well, what the condo authority, the CAT does with those kinds of cost award is perverse, and it completely misses the point of what the condominium is. And it is, I think, an example of just how they've got their focus very wrong right now. And I'm hoping that can be rehabilitated.
I think it can, right? Go ahead,
Well,
Sonia.
hopefully. I mean, I think one way we can rehabilitate it is stop calling condo corps corporations, right? Because everybody gets this mentality that they're a corporation like McDonald's or Walmart or, this independent third party where, any benefit you get is a direct benefit. And like, as Chris said, you as an owner are getting a benefit maybe, but you're paying a portion of it, but you're putting all your neighbors to the expense for that benefit. And I think that's where, the problem is, in this idea of labeling condos as corporations sets up this mentality of that's us versus them, and it's not us versus them. I mean, it's interesting in that Matab case that I talked about, they started off with a $5,000 penalty against the court because they wanted to correct the behavior of the board. Then Mr. Matab comes back and they say, okay, well, we gave $5,000, now we're going to give less. And by the third time, I can't remember what it was, it might have been $300 or something, but by the third time they said, you know what, it's not fair to the other owners who are paying this. So the tribunal recognizes it, they just don't implement that same theory. They understand it, they just don't implement it.
Yeah, I hear you.
So I don't see any questions. There's a lot of stuff going on in the chat. I'm just going to put one more call. We've got 5 minutes left, so I'm going to put out one more call. If anybody wants to ask a question live, now's your opportunity to do so. In terms of questions in the chat, we are seeing a bit of that comment about the us versus them. And I think, this discussion is good. And even the chat discussion, there's lots of people saying, reaffirming the fact that, we're all in this together. Patricia and Chris, do you want to have a quick discussion about our sort of two backup cases on short-term rentals? We've got 5 minutes.
Why don't you lead us off with the facts?
Okay, so there's two cases that came out in 2020. One is the Kumar Bannister versus Tscc 2492 case, and then there's the Perot versus Tscc 2298 case. And both of these cases deal with the issue of a corporation trying to regulate and or ban short-term rentals in a condo. And both of these condo corps had a declaration that basically said something along the lines that owners could lease their units for any amount of time. There was no restriction. The interesting thing I find about this case, other than the result, is that both cases were heard by the same judge within weeks of each other, and were released within days of each other. And the judge doesn't refer to either case in the other case, but makes two very different decisions. In one case, the judge says, yeah, it's okay for the condo corp to put restrictions in place and 6 months is okay. And in the other case, they said, no, it's not okay to put a restriction of 6 months. And they said the rule was inconsistent with the declaration. So we're complaining about CAT, but here's a perfect example of sometimes the courts don't get it right either, because I'm not sure which one is the right answer. Chris, Patricia, what do you think?
Both of them are right. I think it goes under
on what you're arguing, right?
yeah. It's I think just part of it is that's the risk of litigation, is that even when you say, oh yeah, you got a clear violation, clearly you can establish it, anything can happen. And I mean, it goes back to the budgeting and just and taking that kind of risk. And of course, when condo boards are looking at a scenario coming up, if they're able to say, yeah, we're going to have a fight on our hands here, we have to budget appropriately. And yeah, that $500 legal budget might go, not go too far for us.
Yeah. Patricia?
Well, I think just specifically to the issue on short-term leasing, I think it goes back to even the constating documents and what they actually say, and then understanding how even case law that predates this, like Mtcc 1385 and Skyline, and how if you follow those decisions and they work together to clarify where the scope of authority comes for the board, how they can draft it, and what their role would be. I mean, that's all part of getting it right, to even avoid the dispute. And to me, that's one of the things in this case, when I'm looking at, the interpretations and how people are trying to twist and turn, I think you need a good solid foundation, but it comes with the customization of the solution based on the actual docs of the corp.
Yeah, I think it's important because if you look very closely at the wording in the two declarations, although that general principle that there's no time limit, one of them, and the one that won and upheld it, had three little words: for residential purposes as part of the DAC, where the other one didn't. I mean, my take on the case and trying to reconcile them is the case that lost, the Perot case. I think what happened there is that the condo, in terms of their rules and what they set out as restrictions, just went way too far. The case that won and upheld the short-term leasing restrictions, they had very limited restrictions, but the other one kind of went too far, even to the point of saying that if you did a short-term lease, you would be considered a trespasser. So that may be the way we reconcile it. Like you said, Patricia, at the beginning, bad facts make bad law, but it's just interesting that it's the same case, the same judge within several weeks of each other coming to totally opposite conclusions, but not explaining why. So,
but I think that's another concern, right? It's the precision of language. Like, I think all three of us would agree that language is key. The inclusion of three little words can make a difference, but also when writing decisions, that's one of the things where I find sometimes there's a challenge, because I really want to know what was the evidence. What was the thing that triggered this kind of interpretation? Because even on the case with the deck amendment that I talked about with the fireplaces, I didn't see it in the body of the writing. What was the thing that threw the judge over to the side that said there is obviously an error? I didn't see it.
Yeah,
but there must have been something.
It's hard when they don't put the details in the decision that you can actually go back to.
It is.
Yeah.
Right.
Anyway, Chris and Patricia, I love these case law sessions where we get to talk about cases and debate about them. Thank you so much for joining us today. And thank you everyone out there in webinar land for joining us today. Also want to definitely take the opportunity to thank our sponsors again. And shout out to Integrity Property Management, Bayshore Property Management, FCS Fire Consulting Services, and Common Ground Condo Law. Chris, thanks for supporting us. The recording for today is going to be available on our website probably next week. There is also going to be a PDF file put up that will list all the cases that we discussed and their citations, as well as the link to Canley. So if you want to read these cases yourself, you're more than free to go to Canley and find the cases and read them. I want to remind everybody about our upcoming Lunch and Learn in March. So on March 26th, we have Hot 10 Fire Safety Tips. So everybody wear red shirts on March 26th. We're going to go over fire safety tips. On May 14th is our next webinar. Topic is still to be determined, so if anyone has any suggestions for topics, send an email to admin@ccihoronia.com and let us know what you would like us to talk about. Don't forget, all of our webinars that are Lunch and Learn webinars start at 12 and go to 1:30. We are holding our intensive directors course online this year on April 24th and 25th. This will be a 2-day intensive course for directors that will take you beyond the basics found in the CAO course. We are offering this year a special virtual price. Normally our director's course is $250 for members. We are offering it for $100 and $300 for non-members. Details and registration, just go to our website, ccihoronia.com. If you have not joined us on Facebook, please do so. And if you're not part of our emailing list and you want to be, send an email to admin@ccihoronia.com. Ask to be added to the email list. This way you'll definitely know about all of our upcoming events and notices that we send out. In terms of events at other chapters across Ontario, CCI Golden Horseshoe has part 7 and 8 of their enhanced director's course on February 22nd and 25th. You can go to cci-ghc.ca for more information. CCI Grand River has their level 200 director's course corporation governing documents, records, and privacy. On February 23rd, you can go to cci-grc.ca. CCI London is putting on a webinar called Dealing with Difficult Board Members on February 23rd. You can go to cci-sw.on.ca. CCI Windsor on February 23rd, this is a very popular day, is talking about fire prevention in condos. You can go to cci-windsor.ca for more information. CCI Eastern Ontario is putting on a webinar, Proxies, Forums, Oh My. That'll be an interesting discussion on February 24th. Go to cci-easternontario.ca for more information. And finally, CCI Toronto is having a webinar on February 23rd called Condo Security, and you can go to ccitoronto.org for more information. So until next time, I'm Sonia Hodis, and from the entire CCI family to you, wishing you a great weekend. We hope to see you at our next webinar on March 26th, Hot 10 Fire Safety Tips. Michelle Farley from our board is going to be there, as well as someone from the Barrie Fire Department, and we've got some other speakers lined up. So stay tuned and join us on March 26th to find out who they are. Don't forget, CCI is your condo connection. Have a great weekend, everyone.